Hello and welcome to episode 52 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. Today we're going to continue our Untying the Knot series, and we are going to talk about custody, parenting time, and the best interest factors. I'm sorry we started a little bit late today. I had some computer issues and decided to go forward doing it on my phone, which I just really wasn't set up to do today. But we're doing it and it's all good, and here we are. So, hello everyone. I'm so glad that there's people here. So let's just get started because we have a lot to cover. The pandemic has caused a lot of friction in households, and a lot of people are nervous about what it would be like to change their living situation or their family life situation. And so we hope that we're furnishing answers to your questions and really able to give some peace of mind to the decision making that people are going through. And of course, if you have any questions, please post them, message them, just put them in the chat here. Happy to answer them for you. So we talked about yesterday, there's different kinds of custody. There's physical custody and legal custody, and what each of those mean. And we also talked about what an established custodial environment is, about the burden of proof when you're dealing with custody. For custody and parenting time determinations, the court must make a finding that whatever is going to be the outcome is in the best interests of the children. The way that they do that is by using 13 factors known as the best interest factors. And there must be a finding as to who the factor favors, or if it favors neither one or both of them, as far as the parents or the competing parties in a custody battle. So as we talked about yesterday, the competing parties could be a dispute between parents. It could be a dispute between parents and an agency. It could be between parents and grandparents, or parents and a guardian. It could be between a parent and some other relative or friend that's had care and custody of the child. So there's several people, but anytime where a child's going to live and who's going to have legal authority over a child, which is custody, is at issue, or parenting time changes are at issue, it has to be in the best interest of the child and go through these factors. Yesterday we talked about what they are, and today we're going to go into a little more detail about them. So let me just get to my notes here, and we will go forward from there. Sorry, I thought I was on the right page, but I was not. So basically, this is the standard. There has to be competent evidence adduced at trial to each factor in order for the court to make a finding. The parties can agree that it's in best interest of one party or the other, but the court still must make a finding, even if they agree. The Child Custody Act precludes an award of custody where the parent has been convicted of criminal sexual conduct in 2 different circumstances. If a biological parent is convicted of criminal sexual conduct, CSC, or assault with intent to commit criminal sexual conduct, or found by clear and convincing evidence, which is less evidence than you would have in a criminal case, that there was non-consensual sexual penetration that person cannot have custody of a child conceived as a result of the crime. And then there's an unless. If the crime is a conviction based on the situation where both people are between 13 and 16 years old, or in some cases, 17, sort of your Romeo and Juliet type of situations where both people are very close in age, both people, are continuing a relationship, they cohabit, or they are establishing a mutual custodial environment for the child, or they live with their parents. The other instance where a parent convicted of a sex crime cannot get custody is when there have been committed acts of non-consensual sexual penetration with their own child, and that and they also cannot get custody of that child's siblings in that circumstance. But short of that, the offending parent can seek custody or parenting time, and again, it would be decided by looking at the factors. Another thing that committing one of these crimes that bars you from having custody, it should be noted, it does not bar you from having to pay child support. That obligation it's your obligation as a parent to support your children. We talked a little bit about burden of proof yesterday, and I'm not going to really go into that very much because it is complicated and factually driven. So instead, we are going to actually go through and talk about how we evaluate the best interest factors. As I said, they're fact-driven. It depends on the circumstances of the case. It depends on who the parents are, who the children are, the ages of the children. If each parent wins, the same amount of factors, then it's a judicial determination if it should be a joint situation or an equal situation or not. The factors don't need to be weighted equally. It is in the discretion of the court to decide which factors are weighed more heavily than others, depending on the facts. There's several factors that naturally overlap, so some facts can be relevant to more than one factor. For example, if you have a situation where one parent is kind of sabotaging the relationship with the other parent, that's going to count against them in several different factors. Obviously, the ability to facilitate the relationship with the other parent is going to be one of them, and the emotional ties is also going to be one of them that could come in as an overlap factor. If the court determines that there's other facts that are relevant to the decision, that's kind of what I call my 13th factor, though that should also be considered. So in talking about just factors A and B right now, that would be the difference between the emotional ties, which is A, and the capacity to give the child love, affection, and guidance. A is focusing on the emotional bond that already exists between the parent and the child, and that a parent would like to have a better relationship is not relevant. If the parent has become the greatest parent on earth after the divorce was filed, that just is great for your kid, but it's not going to help you win factor A. Factor B, capacity to give love, affection, and guidance. Where both of these factors are projecting the parent-child relationship in the future, B is looking at the ability of a parent to foster the emotional bond in the future and to evaluate the parent's impact on other issues in the child's life, where they need guidance, where with school, education, religion, anything like that. Anything that really will make them a good grown-up when they're no longer a child. So that's what that's looking for. Also, daycare, medical decisions can be considered under B as well. The one case that's interesting was that a court found that factor A and B favored a stay-at-home mom because it failed to credit the working parent for the ability and willingness to earn income and provide health insurance for the minor child, and evidence showing that the working parent was regularly and routinely involved in the minor child's daily care despite working outside the home. So it's misplaced to think because I'm a stay-at-home parent and I do everything all day with the child for the child that you automatically win. The other parent, as the wage earner or working outside the home, is the parenting time or the use of time not at work and how that incorporates the child and the different things that they do is also going to count in B. A lot of people ask about psychological evaluations and if they're a good thing or a bad thing to do. And again, that's a fact-driven determination. Sometimes it sheds a lot of light on a lot of factors in a favorable way, but it can also really hurt. So again, as we've talked about before, you never want to have surprises for your attorney. And if we know about things in advance, then we can protect you from them. We can get the right resources to correct them. We can mitigate them. All of that can come into play. However, if you're not absolutely honest with your lawyer about every ghost in the closet, about every good thing and every bad thing that you've ever done in your life that could come up to haunt you in a custody or parenting time dispute, then you're limiting the amount of help your attorney can give you. And so that is essential. And so, and that really, when you're looking at, the factors, and especially A and B, which are, as I said, they're a projection of the future based on the past. So that's really important to know what the past was. Next is factor C, providing for the child. Obviously, the wage earner is, on his or her face would have get points here. However, that you can rely on facts that show a party's future employment ability, future wage earning ability, future ability to support. For example, if a parent is in school for either a vocation or for a degree that they otherwise didn't have, then that would be important to consider under C. There's also if both parents are contributing, and one is contributing in more an emotional way, one is contributing in more financial way, there's arguments to be made that factor C can be work to favor those parents, because it does provide for, when it talks about what's provided for, it's mostly the child's material needs, but it's going to overlap with the emotional needs and support. Factors D and E deal with stability and permanence. Every child is entitled to a safe, loving, permanent, stable home with a mom and a dad. I didn't say the mom and the dad are in the home. They just should have a mom and a dad in their life. So factor D is going to look at the length of time the child has lived in a stable, satisfactory environment, and the desirability to maintain continuity. Factor E is going to look at the permanence of the family unit or the existing or proposed custodial home. It is not the acceptability of the home or child care arrangements that go into this conversation about D&E. It is purely brick and mortar. This is the home. How long has it been there? Is there any risk of losing it? Do we have to sell it because we need the money to support ourselves as separate parents? So those kinds of things are all going to go into D&E. If one parent is incarcerated, obviously that may cause an upheaval in the permanence and stability of the child's home because they no longer have that parent accessible, and that parent's income may not be coming in as well. Under factor F, which is moral fitness, that's focused and factored into the custody decision, even though we are a no-fault state. As you recall, we talked about yesterday and the day before, actually every day of this, we've talked about being a no-fault state. That means that anyone who wants a divorce gets a divorce. Your spouse doesn't have to agree. Your spouse doesn't have to want it. Your spouse doesn't have to like it, but it's going to happen. And so, but if one of the spouses has been unfaithful, if one of the spouses has played a superior or controlling, dominating role, and one of them was more submissive, if there was domestic violence, that can all come under this moral fitness category. It can also, if the parents were not married and they have at the time that the complaint is filed unmarried cohabitation with each other or with other people, that would also come into play under the moral fitness category. It can really, anything that could be deemed as questionable conduct can come under moral fitness. It could be gambling, it could be soliciting prostitutes, it could be any kind of questionable conduct. It could be going on a business trip and rooming with or sharing a hotel room with a coworker of the opposite sex, and it could be anything that could be deemed bad decision making. Factor G is the mental and physical health of the parties, and this is really an interesting factor to look at, because as we go forward in the world, and Black Lives Matter, and we don't want to discriminate against people with disabilities. We don't favor gen ed students over special ed students. They're both entitled to the same education. Sometimes it's delivered differently, but they're entitled to the same education. So in mental and physical health of the parties, again, there's a policy of pursuing the total integration of disabled persons into mainstream of society. And you can't use a parent's disability against them in a custody determination. And so it's just interesting how even in the family law setting, we have signs that reflect where society is today. So factor G, if you have a parent with anger issues, or whether they're in the child's presence or not, it doesn't have to rise to domestic violence, but anger issues, short fuse, that could be counted against them in factor G. In as far as the physical health, well, and mental health really, if either parent has to take medication, it's not held against them that they have to take medication. It's not held against them that they have a diagnosis. It can be held against them if they don't take the medication, if they don't follow the treatment ritual, and it can be pointed to how that affects their ability to be a parent. In the day of, medical marijuana and legalized marijuana in Michigan, I gotta tell you that is, not very well received in the custody world, because even when parents say, oh, I have it locked up, they have no access, it complies with the law, I think that at least the judges that I've been in front of, they don't buy it, that it doesn't affect your ability to parent. And we do, although it can't be held against you if it's prescribed, and it's locked up and it comports with the law, I think that there's a lot of ways to show that it does affect a person's ability to properly parent. And so can some prescription medications, but that's just kind of a hot topic right now. If there is a psychological evaluation, in order for that person who evaluated to opine on the mental and physical health of the parties, factor G, they do have to go through the rigors of being qualified as an expert witness, and they do have to be, there has to be waivers of the confidentiality, unless it was a court-ordered evaluation in the first place, and then it would already be waived. Factor H is the homeschool community record of the child, and this is, they look at children who are too young to express a preference. The court can determine that the children are too young to have established a home, community, and school record. So if you have a child like under the age of 5, then this may not be a relevant factor for them in that determination. And if the child's older, then their grades, their behavior at school, their behavior at home, those are all things that will be considered under homeschool and community record. Under factor I, the court must take the preference of the child into account if it decides that the child is old enough to express a preference. Now, it used to be the child was 14 or older. Now the law has changed, so it's if the child is old enough to express a preference. Kids at a very young age can express a preference, and there is training on how they are asked this question, how the answer is delivered to the judge or the investigator or the guardian ad litem, and many factors and circumstances and context are important when a child is giving a preference, and their understanding, if they can, of what the impact is of giving a preference. The judge is not required to interview the child, and however, trial courts have found that in most cases, if it's contentious and there's a custody dispute, that the child, if they're deemed old enough, should have some input or express a preference, even if it's not, and I absolutely want to live with my mommy, or I absolutely want to live with my daddy. It could be the best things about being with my mom are doing this, and the best things about being with my dad are doing this, and they're just different. And then it can be decided, because we have facts and we understand what the child is considering in picking one or the other in certain circumstances. for example, if my children had to talk about which parent was better at teaching them how to throw a baseball, it certainly would not be me. So then the evaluator would then look to times when I have one-on-one mentoring or skill building or sharing of experience with the child to offset or make a comparison, or to be able to really tell what the child's life looks like and how significant a role each parent plays in the day-to-day life and the preference and what the preference may or may not be based on. It is not a denial of your trial rights or due process rights if the judge refuses to speak to your children. There are, as I said, there's guidelines for interviewing children about custody preference. They must be followed, and the court is not required to disclose the child's preference. That can be kept confidential and off the record. It does not, as we already talked about yesterday, the child's preference does not automatically outweigh the other best interest factors. You can't change custody based only on the child's preference, no matter how old they are. And so then we go to factor J, which is encouraging parent-child relationships. And that has to do with, no matter how much parents hate each other, can't be in the same room, can't have a civil conversation, can you still encourage and support your child's relationship with the other parent? And sometimes that is really challenging. And this is when you have a situation where a parent was not allowed to have parenting time for a period of time for any reason, and the child is asking, well, where's mommy? And they're being told a variety of things that may be innocent excuses to not tell the truth to a child. Sometimes that can discourage or frighten the child into thinking that there's something wrong or something bad, and then they all of a sudden they don't want to visit that parent. Well, that would not be encouraging or fostering the relationship between the other parent and the child. So it has to be very positive, and the close relationship has to always be supported, and there shouldn't be bad things said back and forth about each parent, and so that's that. There can also be testimony by a psychologist or a professional about parental alienation syndrome or spousal abuse syndrome and the impact that has on this factor. The next factor is K, which is domestic violence. And this factor actually just changed. So, and it came in a scenario with spanking the child as discipline. And the court said that the child witnessed defendant physically attack plaintiff, and defendant did not deny these allegations of domestic violence. In that case, as I said, both parties admitted spanking the child, and the child said that he witnessed the defendant, one parent attack the other parent. There's also, if there's a history of domestic violence, whether the police were called or not, whether or not there's prosecution or not, that could cause someone to win or lose this factor. If you remember from all of last week in our 5-part series about domestic violence, we talked about that it's not just, cuts and bruises. It can be emotional, it can be financial, it can be having someone socially alienated or withdrawn or isolated from friends and family. It can look many, many different ways. So when we talk about domestic violence, we're not just talking about physical violence or sexual violence. The appropriate or reasonable discipline of children, even if it is physical, does not always rise to the level of domestic violence. That is an absolute defense if it is deemed reasonable based on the circumstances. Factor F is any other, I'm sorry, I can't even read my own writing. Factor L, not F, is any other relevant factor, and that could be, I'll tell you that it can't be based on race or religion, but those could be considered if you do have a mixed racial couple, and the child's being raised traditionally, for example, in the Asian culture, and they get divorced. There you have to have a discussion, and it could be considered if the other parent doesn't want to continue to raise the child in the Asian culture or support the raising of the child in the Asian culture. Of course, the age of the child is going to come into play there as well. And it's also considered here if the children have different preferences, it's considered presumptive that it's in the best interest of children for siblings to be kept together. If they have different preferences, then maybe there's other things that need to be considered here to determine the best interest. Child care arrangements can be considered here. There can be, if there's different rules in each household, if there's, it's going to be a free-for-all here and it's going to be really strict here, that could be considered here. If there's financial manipulation, if one parent is saying, when you live with me, I'm going to buy you, a PS4, and you're going to have a continuing subscription to every upgrade of Call of Duty, and they're like 10 years old, that could definitely be something to be considered here. If the court cannot determine, based on the information provided by the parties, what is in the best interest of the child, or if the court needs more information in regard to some of the facts that were presented, a guardian ad litem might be appointed. Guardian ad litem is a neutral investigator who really represents the information being sought and the integrity of that information. The guardian ad litem, or GAL, does not represent the children, but represents the best interests of the children and investigates and informs the court accordingly. And we had a whole session on guardian ad litems already, so I'm not going to go through all of that, but we will talk about another issue that can come under this kind of umbrella. Anything else that we have to remember is if one of the parents is moving out of state, and so there obviously will not be continuity, or if both parents are moving out of state, and so that can come into play. The proposed parenting times can come into play. As I mentioned earlier, if you are in a situation that you need an ideal parenting plan when one parent is more than 100 miles away, the Lapeer County parenting policy is the best version I've seen. Just very well thought out, very well contemplated. It really thinks about all different kinds of situations when parenting time can occur if the children and the out-of-state parent end up in the same place, either accidentally or for scheduled parenting time. Talks about, who bears the costs of the flights or the transportation, different ages, when it's appropriate for a child to fly unaccompanied, all different things like that. So, a custody order, what is that? It's very important because if you don't have your agreements in the form of an order, they can't be enforced. And what that means is if you go to pick up your child during your parenting time and you don't have an order that says it's your parenting time, then the police cannot get you your child. Vice versa, if you keep the child and don't return the child to the other parent, if there's no order, the police cannot help you. The police don't like to help you anyway, so at least if you have the right paperwork, you have a chance. The custody order will include a prohibition against moving the child out of the state of Michigan. It will also require that that if either of the parents moves, they immediately inform the friend of the court of the changing or moving or modification of the child's residence. They have to also declare the child's inherent rights in to have custody support and parenting time from both parents. They have to talk about joint custody arrangements and what that actually looks like. And then they have to also agree on the child support number that can be put in a custody order. It can be a custody and support order. We enter usually a temporary order when the case starts if the parents aren't living together. And then that temporary order would be modified by the final custody order or the judgment of divorce. And that's what that would be the rule book going forward. Remember, with custody and parenting time orders, as I talked about yesterday, it is the minimum. It is the absolute least amount of parenting time a parent should have. You can agree that there'll be more, that there'll be, we're all going to do this extra thing. We're going to change the days. We're going to extend the weekend. Whatever it is, the order is the safety valve to make sure that there's something enforceable if a parent is not seeing their child, that they can go to court and ask for relief and make up parenting time if the court deems it appropriate. So that is basically, what goes into a custody order. So what do these parenting time schedules look like? I think that that's something that people get tripped up on a little bit. They look like whatever you want them to look like, but we try to seek permanence and stability and for the children to know what's happening on what day. So, for example, you would not want to have a schedule where on different days the child is at different houses in different weeks. So when we're looking at making a schedule, we usually do a 2-week block and we figure out how many overnights each parent is going to have, and then we map it out. And it can look like, it can be, 2 days with one parent, 2 days with the next parent, 5 days with, parent number one. And then it becomes 2 days with parent number two, 2 days with parent number one, 5 days with parent number two. Okay? That's one way we do it. One way we do it is one parent gets every Monday and Tuesday, one parent gets every Wednesday and Thursday, and they alternate weekends, Friday to Monday morning when the child goes back to school. So we can be really creative, but we have to draw it out to make sure that it is easy for your child to understand. And then all the other decisions can be made. So that's where I'm going to stop for today. Tomorrow we're going to talk about some of the things that have to be decided before you write a judgment of divorce, and what's in a judgment of divorce, and how you enforce your judgment of divorce. So that will be tomorrow, and and then we'll continue next week. But we're going to start over because we'll be out of quarantine next week. So we'll have some new series, and I will preview those for you tomorrow. But I just want to tell you how much I appreciate all of you and spending your sort of late lunch hour with me. And so I look forward to tomorrow on seeing you. I did not look up the COVID numbers today, but unfortunately the trend is not declining as rapidly as it had been before. And as I mentioned, that's because of the Missaukee County, Muskegon area of the state. So with that, I'll give you the 5 reasons. Protective services workers are essential. The police are essential. The jails and prisons are hotbeds of COVID-19. We're not even sure if it's really, peaked in there yet, as the population changes and there's so many people going in and out who either work there or treat and provide services for the inmates. Kids being kids can get their parents in trouble. And number 5, of course, because very few people, if anyone, look good in horizontal stripes. So with that, I will say good afternoon to all of you. I hope you're well and have a great day, and enjoy, and I'll see you tomorrow. Bye.